Mariano delli Santi, is a legal and policy officer at the Open Rights Group, where he supports strategic litigation and political advocacy efforts. He currently works on promoting privacy in the online advertising sector and, I quote, opposing the UK government plans to scrap the UK data protection regime. You probably have seen the open consultation, and they have actually responded to this open consultation on data, a new direction. We will probably hear something about that. He also a Juris Doctor in law from the University of Milan, where he graduated with a thesis on online anonymity. He also holds a Master of Arts in IT law from the University of Tartu. He previously worked as data protection officer for a political party and as a legal counsel in the field of data protection and legal tech. So I'm going to share the slides that you sent us. And yes, Mariano, feel free also to come here. So everyone online will listen your voice.
Hi, good morning, everyone. And I apologize in advance if I will lose the thread of the conversation, but I came here with the night train and I didn't sleep much. Anyway, so speaking about, so this is the only slide that I actually have to present to you today, because this relates to the exactly the campaign that Open Rights Group is running about the government plans around data protection. The Open Rights Group, just to give a brief introduction, is a digital rights organization based in London. It fights for freedom of expression and data protection / privacy in an online world. And we also have local supporters and local chapters spread all around the United Kingdom. So feel free also to look around, and if you're interested in our job, maybe to become a supporter or a member, or get in touch with these groups as you go forward. Anyway, so to give a bit of an introduction about what the government is, so what is going on with data protection in the United Kingdom. For the sake of this conversation, we will start from 2020, and in particular in April. You might remember there was the coronavirus outbreak, and a lot of things happened from there on. Among these various calamitous events that there was in there, there was also Dominic Cumming that started blogging about the GDPR and how this didn't allow the United Kingdom to fix COVID or something like that. And following on these words, the then led by Oliver Dowden, let's say DCMS, published two documents. One is the 10 tech priorities, and the other one is the national data strategy, where basically they talk about the importance of data for doing stuff. And following on this, there was another report wrote by what is called an independent task force, TIGRE, that is actually three members of parliament from the Conservative parties advising a Conservative minister. And let's say one of those was Ian Duncan Smith, anyway, just to give the idea about that. And let's say they talk about basically the GDPR there, and the idea of scrapping the GDPR and substituting this with something which is kind of a let's say a British citizens data rights regime or something. And we finally arrived to Data New Direction, which is the last document produced by the DCMS, exactly in between the transition between Oliver Dowden and Nadine Dorries. And it's a 140 pages document where the government starts to think about how a new post-Brexit GDPR regime could look like in the United Kingdom. And let's say, having reached this point, I guess that the question that might be hunting this room is what this dream team has come up with. Let's say, what are the bright ideas that they produced in order to change the data protection regime in the United Kingdom? Well, they start from this very original assumption that data is the new oil, and therefore, if you cut red tape, you will spur growth and innovation, and everything will go well. And they outlined, well, to be honest, a lot of changes. I won't go into all of them, but there are at least 3 areas that I want to cover.
Sorry, before the 3 areas you want to cover, just because I'm checking the online group. If you can just stay 2 steps behind, yeah. So they are going to see you. Otherwise, they were going to see. They were seeing your chest.
Okay.
Anyway, they will hear your voice very nice and clear, but now they will also see your face. So apologies. Again, this is the wonderful organization of hybrid conference. Things that we have to check.
Anyway, so okay, let's say yeah, I will divide the presentation into 3 main areas. One is about the legal standards of data protection. So basically data protection rights. The second one is about the data subjects rights, so the rights of the individual. And the third one is about what makes data protection from theory to practice, so the accountability framework and the independent oversight of the ICO, or of the alleged independent oversight of the ICO. Anyway, so starting from the first one, let's say things that are important here is the government is fundamentally looking forward to change rules around the further processing of personal data, so the reuse of personal data. They want to make it easier to reuse data beyond the scope it was originally collected, or beyond the consent that you gave for the data to be reused. They also want to, let's say, extend the application of the scientific research exemption to other activities, such as the use of, say, development of AI and stuff like that. And they want to make it easier to apply restrictions to data protection rights when it comes to repurposing in the substantial public interest. So they want to make it easier for the government to make a law that allows the further use of data for whatever they believe it's a substantial public interest. And finally, they also talk about the legitimate interest legal basis of the GDPR. And there they propose to scrap the legitimate interest assessment. So they fundamentally would allow processing in the legitimate interest without balancing this against the rights and freedom of the individuals concerned. So we don't have time. I mean, like, in the interest of time, I guess that it's you more than going into the single details of what is being proposed. I think it's interesting to remind why, let's say, purpose limitation is important. So let's say, what is the reason that we have things like, let's say, the idea that you collect data for a purpose, or for something that the data subject has consented to, and then you don't reuse this data beyond this original purpose. And this is exactly because, let's say, context and shapes the understanding and the expectations of the individual about how this data is being used. And the concept and the GDPR was exactly meant to empower individuals to have control and to have remedies about their data and how their data is being used by third parties. There is basically value here in respecting these expectations and making sure that people understand basically that if they're giving their data in a given context, they can reasonably expect this data not to be reused beyond that, or let's say to be abused. And let's say, because of so this is one of the issues. The other issue is always related to purpose limitation, but here we introduce another concept, which is that of the principle of legality. In the current data protection framework, data processing must be legal. So there must be a law that determines what are the specifics. So what, let's say, are the conditions by which you determine whether something is being done legally, lawfully, legitimately, or not. And it also poses, let's say, safeguards around this use. So for instance, when it comes to consent, you will have a safeguard where consent must be specific, informed, and ambiguous. You must be able to withdraw your consent with the same ease by which you actually gave it. When it comes to a contract, the contract, well, you will need first of all to be in a contract, but most importantly, let's say, you will be able to process data for the, let's say, doing a contract basically, only and insofar it is necessary. So it's kind of, there is a limitation on the kind of activities that you can justify under this legal basis. And finally, there is the legitimate interest. Legitimate interest is a bit different among the lawful basis, exactly because it's open-ended by nature. It doesn't specify what a legitimate interest is. It asks the controller to define this, but it asks the controller also to exactly carry a legitimate interest assessment. So basically to put on the one hand, the reason why you're doing this, on the other hand, what is the possible impact or adverse consequences that the individual might experience because of this. And based on this balance to see whether you actually have a legitimate interest or whether, you know, like you're just hurting someone. And scrapping this balance basically means to create many new lawful bases which fail to do what a legal basis is supposed to do, which is to give foreseeability and to give safeguards against abuses. And to give you an example, one of the legitimate interests that the government would like to be always legitimate, regardless of a balancing assessment, is, let's say, are things like, let's say, improving services for customers. So like we are improving your services, or let's say safeguarding concerns. So they are very broad definition. The government also wants to have regulatory making power to basically extend this list and add further proposals as they go forward. It fundamentally creates a situation where exactly where the GDPR was supposed to create, let's say, create trust and create an environment where you understand what is going on and basically are empowered, you will end up in a situation where effectively you give data to somebody and you don't know what's going to happen afterwards, simply because they can be reused beyond that purpose in a very liberal way. So this is the first one. Going to the second topic that I mentioned before, which is the rights of data subjects. There are three main rights that come into play with this consultation. The first one is the right of access, so the right of obtaining a copy of the data from the controller. The second one is the right not to be subject to an automated decision, which is not reviewed by a human, so Article 22 of the GDPR. The third one is the right to lodge a complaint. And to make, let's say, to make it easy, what the government is doing here is basically to put barriers between the data subject and the exercise of these rights. So for instance, when it comes to the right of access, they want to impose a data protection fee. So the data subject will have to pay the organization in order to access their data. They want to put a cost capping limit. So basically, if let's say, if it will be too expensive for an organization to answer to this request, they will be exempted from answering. And they want to empower, generally speaking, the organization to be able to ask the individual why they are making this request and maybe refuse it on the basis that the data subject is considered annoying by the controller or whatnot. When it comes to Article 22, the GDPR is more or less the same. They're considering whether to scrap it entirely or to make it more difficult to rely on it, or rather extending the exemption that you can rely on in order not to be subject to this prohibition from using automatic decision-making against an individual. And this is very relevant exactly because the reason this norm exists is because individuals don't have access to the automatic systems of others. And of course, they are not in a position to understand, they're not in a position to review whether these decisions that are affecting them significantly are, let's say, right or wrong. If a computer says that you're not credit worthy, you don't have access to basically the logic involved in that. The controller has the access to this logic. And therefore, it is important that it's the controller that basically takes the responsibility of making sure that this decision is reviewed and, generally speaking, that it doesn't hurt the individual. And finally, when it comes to, let's say, the right to lodge a complaint, here as well, they want to require data subjects to basically try to resolve their dispute with the controller before, let's say, lodging a complaint to the regulator, which, I mean, is, first of all, from a point of view of principle, a bit complicated, because it's kind of, imagine you're being robbed in the street and you call the police and they tell you, how about you call the thief before and try to solve this thing with them. But most importantly, the point there is let's say the right to lodge a complaint is exactly a mechanism of self-defense that the individual is supposed to have and is supposed to exercise in the way they see fit, posing a bureaucracy administration, posing steps that they must take, and basically asking an individual to behave like a lawyer and do a pre-action protocol against an organization before lodging a complaint. Let's say, is against the fact that most people are not lawyers and they don't have this mindset. But most importantly, it exposes individuals to a situation where they will probably make mistakes, and then the organization that actually made the offense will have something to leverage in their defense when it actually comes to the complaint, assuming that the complaint actually escalates. So this is basically the leitmotif here. I mean, like where the GDPR was trying to empowering data subject to basically have rights over how their data is being used, the government is looking forward to introduce barriers, so generally speaking, to protect controllers from what could be the claims or the expectations of data subjects. Yeah. Okay. So, well, yeah, there were a couple of other things about accountability and independent oversight, but I guess the main point here is let's say there are two things that the government is saying there, that they want to retain high data protection standards, but also they want to, let's say, promote growth and innovation. And here is kind of, if you look at the changes that the government is proposing from the lens of data protection, it doesn't make a lot of sense, because why are you trying to do these things if you want to protect the individual? However, if you look at these things from the point of view of data is become a commodity, it's become the new oil, and therefore you want this to be traded in a free market, which is unregulated with laissez-faire and so forth. Let's say what the government is proposing suddenly starts to make sense. And what's the problem of this vision? Well, the problem of this vision is exactly that today we know that innovation is not, let's say, a blank concept, it's not neutral. And generally speaking, when we talk, let's say, innovation cannot be seen as the government is seeing this as simply the idea of having new things that are being developed. But there is a question that must be asked in terms of who's reaping the benefits of this innovation and who's instead being harmed, and how do you deal with the harm that innovation might bring forward. This is a bit the problem that this, let's say, if this vision of data protection concretizes in the United Kingdom, will start to be to hit and to be relevant. Let's say the fact that we will end up in a situation where innovations are new things, and let's say we will have to adapt to innovation rather to have innovation or new technologies that kind of adapt to our needs. Yes, because I was asked to wrap up, so I will disappear, and thanks everyone.